Kyle. Hello, everyone. It's our pleasure to be here tonight to talk to you about some of the new protections that are in place to help tenants during this challenging time. My name is Matt. I'm a staff attorney at Tzedek in the Preventing and Ending Homelessness Project. We'd like to thank the LA Library for hosting this event. Now, this afternoon, we'll talk about the eviction process in brief and mention some of the general protections that you have in the city of Los Angeles, protections like LA's rent control ordinance, whose protections have not changed during the current crisis. But we want to focus on the new tenant protections that have been set up by municipalities, by the state. These have been put in place because of the pandemic. You will have an opportunity to ask questions. You can use the chat feature. So I would welcome you to do that. And we will begin. So our agenda today. It's important, first of all, to note that our presentation today covers only the current situation in the city of Los Angeles. These have enacted protections that are very different from those we will discuss today. Also, today's webinar reflects the new protections put in place as of today only. The situation is rapidly changing, and tomorrow might bring changes to the tenant protections, and we cannot predict what those will be. In today's webinar, we will talk briefly about the eviction process before COVID-19 and about the protections that tenants already have in place. Next, we will talk about the special protections that tenants in LA City already have because of tenant protections like the LA Rent Stabilization Ordinance. Furthermore, there is a new statewide law that went into effect on January 1st, 2020 called the Tenant Protection Act of 2019, or AB 1482, which protects tenants in some cases where tenants do not have the advantage of local rent control laws. All of these laws existed pre-COVID-19, but they are still in place now. Most importantly, however, the webinar will focus on the new protections that LA City has set up to help tenants during the COVID-19 pandemic. These protections include information on what to do if tenants cannot pay their rent and whether landlords can raise their rent now. Tenants have a lot of questions about paying their rent, whether they even have to pay their rent, whether landlords can come and change the locks and force them out of their units. We hope to address these questions tonight and clear up any misconceptions. Again, you might read on the internet or newspapers that there's total rent forgiveness. We really want to bring a coherent message for everyone today. Next slide, please. Now we're going to talk a little bit about evictions in general. Eviction is the process in which a landlord sues a tenant for possession of a rental unit. A landlord must follow certain steps according to the law. Now it all starts with the landlord giving the tenant a notice of termination. There are different notices of termination depending on the circumstances. A tenant might get a notice to pay if the landlord claims the tenant owes rent. A notice to cure if the landlord claims the tenant has violated a lease provision, or a notice to quit if the landlord believes that the tenant has committed a very serious violation, one that cannot be fixed. In the first two cases, the tenant has the opportunity to fix the alleged problem, pay the rent, get rid of the cat if the cat's the problem, not on the lease. There are other notices that a tenant can receive, a 30, 60, or 90-day notice, and these notices typically do not call into question the tenant's behavior. Let's say, for example, that a tenant gets a 3-day notice to pay, and the tenant does not pay the requested rent during the 3-day period. Now, the landlord can file a complaint with the court and serve the tenant with a summons and complaint. A picture of a summons is on the left. The complaint sets out the landlord's case. That is non-payment, lease violation, a pet. The lease says no pets. The summons is the court's way of telling the tenant that she's being sued and has 5 days to respond by filing an answer or risk a default judgment. A default judgment occurs when the tenant fails to respond to the landlord's complaint within the 5-day window, within the 5-day period to answer. It means the tenant no longer has the right to go to court to fight for her rights. The notice And the summons and complaint must be given to the tenant in the way the law requires. This is called service. The landlord cannot simply email the documents or text them. Service must be done according to the law. Now, once a tenant files an answer, both sides prepare to go to court. In many cases, landlord and tenant can resolve the situation without having a trial. This is called settlement. Settlement might allow the tenant to stay if he pays the rent or move out of the unit under favorable terms. If landlord and tenant cannot settle, they go to court and a judge or a jury decides who wins. If the tenant wins in court, the tenant can stay in the unit but has to pay back rent, has to pay rent, including back rent if required. If the landlord wins, the court issues a writ of possession. The landlord can then take this document to the LA County Sheriff Department and the lockout process begins. Under normal circumstances, the sheriff will come out to the property 5 to 7 days after the court judgment or default and post a 5-day notice to vacate. Next, the sheriff comes back out to the property and finalizes the lockout. You and your belongings must be out of the property by the second time the sheriff comes out, or you might lose your belongings. It's important to note that tenants already have strong protections in place against eviction, regardless of where they might happen to live in the state of California. These state law protections require that tenants provide a notice of termination, as we just saw, and only after that proceed with the formal court process of eviction by filing the complaint. Tenants have the right to respond with their legal defenses. For example, if a landlord claims that the tenant did not pay rent, tenant can claim, I deny your claim that I didn't pay the rent. I also assert that you did not fix the faulty plumbing 3 months ago, even though I asked you. So this is an example of one of the many defenses that a tenant can raise according to state law. Landlords cannot simply require that tenants leave. They have to follow the law, which gives tenants time and the ability to defend their legal rights in court. It's important to stress that getting a 3-day notice to pay, cure, or quit, or any other notice for that matter, does not mean that you have to leave your apartment. It means only that if you don't do what the landlord asks within that 3-day period, the landlord can go to the next step in the process, which is filing and serving the complaint and summons. No matter what, tenants are allowed to defend their rights in court, but they have to respond to the complaint within the 5-day period or they lose their right, they lose their proverbial day in court. Next slide, please. So now we're going to be talking about the capstone of tenant protections in the city of Los Angeles, the LA Rent Stabilization Ordinance, or LARSO abbreviation. It offers extremely strong protections. It provides for a limitation on rent increases for eligible units and eviction only for so-called just cause, which I'm going to define in just a second. LARSO's definition of eligible units are dwelling units in buildings first occupied before October 1978, located in the city of Los Angeles, which contain 2 or more dwelling units. For example, a single-family house would not be eligible under LARSO if only one family lives in that house. If that house has been partitioned into independent dwelling units for different families, then it very well might qualify for LARSO. The maximum rent increase possible is 4 to 6% a year, depending on whether the landlord pays gas and or electricity. Now, besides these rent increase protections, LARSO also offers just cause protections against eviction. These protections limit a landlord's ability to end your tenancy. Rent control means that a landlord generally needs a good reason to end your tenancy. Without these protections, a landlord could end your tenancy for any reason, basically, as long as it's not a discriminatory reason. Just cause refers to 2 different types of situation. The first is where the tenant is allegedly at fault because they didn't pay the rent, or they violated the lease by keeping that pet, or damaged the unit. The landlord can try to evict for these reasons. Now, the second situation includes cases where the tenant is not at all at fault and completely blameless. The law allows the landlord to try to evict a tenant if the landlord wants to move into the unit himself, put a manager in the unit, or an eligible relative. Also, if the landlord wants to remove the entire building off the rental market through the Ellis Act, the law allows the landlord to do that, but the landlord must follow strict rules. In cases where the landlord tries to evict the tenant, and the tenant is not allegedly at fault, the law requires that the landlord pay the tenant relocation assistance money. Now, the amount payable depends on factors like age of the affected tenant, length of the tenancy, and whether there are minor children in the household. LARSO, that is the LA Rent Stabilization Ordinance, gives you these protections, and you cannot waive them or give them up voluntarily or involuntarily. The landlord cannot force you to sign a document where you give up your rent control rights. So there's no way that you can contract out of these protections. They're yours. Pre-COVID, during COVID, post-COVID. Sorry, one slide back, please. Thank you. Now we're going to be talking about protections for tenants who might not be protected by LARSO. California has a new state law that went into effect in January 2020. It's called the Tenant Protection Act of 2019, or AB 1482. Now, it offers a yearly rent increase, rent limit of 5% plus inflation, which in these parts, inflation amounts to about 3.3%. So that would come to about 8.3% here for eligible units yearly, and just cause protections against eviction. And we just talked about what just cause means. Eligible units are those first occupied more than 15 years ago on a rolling basis. The new state law offers protections for those tenants not covered by LARSO. For example, if someone was living in an apartment building in LA that was first occupied in 1996, it wouldn't be covered by LARSO because LARSO cuts off in 1978, but would be covered by the new state law if the other conditions apply. Tenants living in a single family house with a corporate owner would be covered by the new state law, but not by LARSO. So in this way, the new state law can serve to fill the gaps in those areas where tenants are not protected by local rent control laws. So now I will be turning over the presentation to Hana.
Thank you, Matt. My name is Hana, and I'm a staff attorney at Tzedek. Matt has done a great job of laying the groundwork for the protections that existed before COVID-19 and the way the eviction process generally works. And now we're going to transition to talking about how things are happening during the COVID-19 pandemic. So I want to highlight that, first of all, right now, again, we're just talking about the city of LA, and we're talking about specifically protections for residential tenants. There are also protections for commercial tenancies, but those protections are a little bit different, and that's outside of what we're going to cover today. And so on the right of this slide, you'll see sort of a cheat sheet that we've created to help tenants understand how the protections work. And we're going to break this down line by line so that each part of the protection makes sense. And then finally, it's important to remember that these protections that we're about to talk about, there is one exception, and I'll address that. But everything aside from that exception applies to all residential units in the city of LA. It doesn't matter whether they're rent controlled. So Matt just explains that, if you are covered under LARSO, then you have certain protections, but these protections for residential tenants during COVID-19 actually, relate to all residential rental units within the city. Next slide, please. So you may have heard about emergency protections relating to rent payment and eviction for people that can't pay their rent due to COVID-19. And so in short, people that can't pay because of COVID reasons get an extension of the time to pay their rent. And in the meantime, they can't be evicted for failing to pay their rent. So first, let's talk about who these protections apply to. So the law applies to tenants who are unable to pay their rent due to financial circumstances related to COVID-19. So this could include people who have lost income because their workplace was closed, or they were laid off, or perhaps had their hours cut because of COVID-19. It could also include people that can't pay their rents because they've had increased childcare expenses now that schools are closed. It also includes people that can't pay rents because of healthcare expenses related to being sick with COVID-19, or caring for a household member or family member who's sick with COVID-19. And it also includes people that can't pay rent because they've had increased expenses from their efforts to comply with government-ordered emergency measures. Next slide, please. So all of those people we just described who can't pay rent for COVID-related reasons are protected tenants. And so for these protected tenants, they can postpone or defer their rent payments until after the local emergency period ends. And so this local emergency period, we're going to talk about it a little bit. And so on March 4th, Mayor Garcetti declared a period of local emergency in the city of LA. And that means that there will be a local emergency period in effect until he decides to lift it. So tenants will have until 12 months after the local emergency period ends to pay back any of their back rents. So for example, so it's May 20th now. So if the local emergency period ends on June 15th, 2020, so that would just be in a few weeks from now. And this is just an example. This is not what we're saying would happen. But if they did end the local emergency period on June 15th, and if the tenant didn't pay their April rent, May rent, or June rent, the tenant would have to, first of all, start paying rent going forward in July 2020. And then they would have until a year after the emergency period ended. So that would be, sometime in June 2021 to pay back the rent they owed from that time period. And of course, if the local emergency period ends later, then that year the clock would start ticking on that year later. So in the meantime, during the local emergency period, and then during that 12-month period that tenants have to pay back their rent, in the meantime, tenants can't get evicted for non-payment of rent. And this is really important because this we've really seen a lot of tenants so far or have a lot of concerns about this because they're worried, given that everything that's going on, they're worried that they're not going to be able to pay their rent and that they're going to lose their housing. So it's very important for tenants to know that, if they do fall into one of those categories we just described, then they are protected and they can't be evicted for failure to pay their rent during this period. So landlords also can't charge late fees or interest on the unpaid rent. And then it's important to remember that, rent has been deferred or postponed, but it has not been forgiven or canceled. So as of now, tenants will still be required to repay any unpaid rent within a year of the local emergency period ending. So again, your tenants will still owe their rent eventually. It's just being postponed. And again, these protections apply regardless of whether your unit is rent controlled. Next slide, please. So you might be wondering how you can take advantage of these protections, and if you have to tell your landlord that you're protected under this law. And so technically speaking, the law in the city of LA doesn't require tenants to notify their landlord that they're unable to pay rent for COVID-related reasons. But we still strongly recommend that tenants notify their landlord that they're unable to pay rent because of COVID-19. There's a couple of reasons for this. One is that if your landlord has been asking you repeatedly when you're going to pay your rent, and you've maybe missed a couple of payments so far, your landlord might back off in trying to get that payment from you if they know that you can't pay due to COVID-19. And then so that is definitely a reason to consider telling your landlord. The other reason is that if you do send notice to your landlord now, that could help you in the future if, somewhere down the road your case ends up going to court. And because of, we really don't know how long we're going to be in this period, and there is kind of such a long repayment period, we don't really know when these cases are going to end up in court. And we certainly hope it doesn't come to that, but we do think it's good to keep that to give that notice now and to keep records of that notice, because you just don't know if you might need it later. So we definitely recommend that you notify your landlord in writing. This could be through a letter or email or even text messages. And you should do this as soon as possible after the rent is due. So for instance, for June, if you can't pay your June rent, then you can notify now, or you can notify on June 1st, or as soon as possible, really after that rent is due. But even if a month has already passed, let's say you didn't pay your May rent or even your April rent, you should still go ahead and notify your landlord anyway, because like we said, there are reasons that just providing that notice may help you. And if you can't pay for multiple months, like if you couldn't pay May rent, and then you also can't pay June rent, we think that just to be safe, you should send a notice each month. So in May, send a notice that I can't pay my May rent, and then in June, send another notice and say, also because of the pandemic, because of my financial circumstances related to the pandemic, I cannot pay my rent in June. Next slide, please. So there's a sample letter on Tzedek's resources page. And, at the end of this slide, we're going to talk a little bit about resources, and we'll show a link to our website. So we have a sample letter for tenants to notify their landlords of their financial circumstances. And there's also a sample letter on the LA Housing and Community Investment Department's website. And we recommend that however you send the letter, that you make sure that you keep a copy of the letter and proof that you gave the notice and when you gave the notice. We recommend that the letter, if you whether you're using our template or something else, we recommend that the letter explains in general terms why you can't pay your rent due to COVID-19. So for example, I can't pay my rent in June because I have experienced the loss of income because my workplace closed. Next slide, please. So in the city of LA, there's no need for tenants to send documents about their financial circumstances to their landlord. In general, we don't think that there's a reason for tenants to give landlords this private information right now. And we know that a lot of the information that you might be thinking about, like bank statements, are certainly personal information. So you don't need to provide any sort of documentation along with your letter to your landlord. But we do recommend that tenants make sure they have these documents, because later on, and again, this could be in a year or more, tenants might need to prove in court that they were financially affected by COVID-19. And so it's good to just be ahead of the game and make sure that you do have those documents. And so some examples of documents that could show your financial circumstances include things like paycheck stubs, bank statements, a letter from your employer about your workplace closing or about layoffs, bank statements that show that your income isn't coming in, or things aren't coming in regularly anymore. A doctor's letter, or any sort of medical documents, hospital documents that relate to being sick with COVID-19, or a notice of school closure. And we understand that you might not have all of these documents depending on your circumstances. A lot of our clients don't have bank accounts, for example, and so they wouldn't be able to provide bank statements. But we recommend that that you be creative about this and just gather whatever you do have that's proof, and just put it aside in case you need it. Next slide, please. So given that so many people are unable to pay their rent right now, a lot of landlords are asking tenants to sign repayment plans. And the important thing that you should know is that you don't have to sign a repayment plan. Your landlord cannot make you do this. And frankly, we think that you should be careful about signing one right now, given that there's so much uncertainty about how long this period is going to last. We're still not sure when certain businesses will reopen, and even when they do, exactly what that's going to look like, and how many people are going to be visiting those businesses. And so we think that tenants should be extremely cautious about committing to paying a certain amount per month when it's really unclear right now what their expenses and income might be in the future months. And again, with all of the protections that we just described, it's important to remember that tenants who are unable to pay their rent because of COVID-19 are not obligated to pay right now. And so because you do have that protection, it's just incredibly important to be careful about committing to pay any more than you're able to. So we definitely recommend that you seek legal advice before agreeing to any payment plan. And then one other thing, related to that, is that tenants do not need to turn over their stimulus check. So many tenants right now are getting stimulus checks from the federal government. Of course, not all tenants qualify for these. And we have heard in some situations that landlords are telling tenants they have to turn over their stimulus check. And so this is not true. In fact, the LA City's law specifically says that landlords cannot force tenants to pay the landlord any money that they've received as part of a government relief program. So that would include, any stimulus check or unemployment assistance. So, even if you do hear something from your landlord requesting this money, you should know that you're not required to provide that money to them. Next slide, please. So there are a few other ways that the emergency tenant protections can help tenants. So in general, evictions for no fault reasons are prohibited during the local emergency period. So no fault reasons include when an owner or their immediate family needs to move into the property so that, so the tenant needs to vacate to allow them to do that. The no-fault reasons also include when an owner wants to take the property off of the rental market entirely, which is known as an Ellis Act eviction. Another example is when an owner is substantially remodeling the property and the tenant can't remain in the unit while those renovations are taking place. So no-fault evictions usually begin with a 30 or 60 or 90-day notice to quit. Ellis Act evictions would begin with a 120-day notice to quit. And so this prohibition, this general prohibition against most no-fault evictions applies to all tenants, not just people that can't pay rent due to COVID-19. And again, as before, it doesn't matter if you're under rent control. This will still apply to you. Now, in relation to the Ellis Act, which I just mentioned, allows landlords to remove a unit from the rental market entirely. Ellis Act evictions, not only are they prohibited during this time, there are also additional restrictions that apply even after the local emergency period ends. So landlords can't terminate tenancies under the Ellis Act until 60 days after the local emergency period ends. Another protection is that during the local emergency period, landlords can't evict tenants for unauthorized occupants, pets, or nuisance if they are related to COVID-19. So for example, if you have to take in your cousin during the pandemic because she didn't have a place to self-isolate, your landlord wouldn't be able to evict you for having an unauthorized occupant in your unit. Landlords are also required to inform tenants of the new emergency protections. And if a landlord does go ahead and file an eviction complaint, then they are also required to provide this notice. Landlords are they're supposed to comply with all of these protections that we are describing today. It's possible that in some cases, a landlord might not follow everything that the law is saying. So for instance, a tenant might have told them that they can't pay rent due to COVID-19, and the landlord serves a 3-day notice to quit and files an eviction complaint for non-payment of rent, even though they already know the tenant can't pay rent due to COVID-19. And so in those situations, there's a private right of action for tenants. And so tenants can use this when landlords violate these emergency protections. And what a private right of action means is that tenants can file civil lawsuits against the landlord. We definitely recommend that if anything like this happens where you feel that your landlord is violating the law and not complying with these emergency protections, that you contact us for legal assistance. And again, all of the protections on this slide apply to all units in this, residential rental units in the city of LA, and so not just units that are under rent control. Next slide, please. So, okay, so for everything we've talked about, as I just mentioned, applies to all units, all residential rental units in the city of LA. But there's also a rent freeze in effect. And this is that exception I was talking about, which is this protection applies only for occupied rental units that are under LARSO, under the city of LA's rent control law. So if your unit is covered under LARSO, that means your landlord can't increase your rent until a year after the local emergency period ends. And so that again is the one exception that applies only to rent controlled apartments. Everything else that I've discussed today applies to all residential rental units in the city of LA. And before handing it off to Ysabel, I just want to mention that tenants might have also heard about the county of LA passing its own eviction protections. And so this is true. The county has passed tenant protections, which in many ways are similar to what we've described today. They do vary somewhat. But because the city of LA has passed its own protections, the city's protections apply. So somebody that lives within the city of LA should follow the city laws and get the protections from the city law rather than the county law.
All right. Hi, everyone. My name is Ysabel. I work at Tzedek, a part of the homelessness and prevention program. So I'll be talking about the status of eviction cases in LA County. Most eviction cases are postponed due to court closure. The Los Angeles County Superior Court is closed for the time being. They will begin hearing unlawful detainer trials starting in June, and jury trials later on at the end of the summer. What that means right now is that courts cannot issue a summons in an eviction case. A summons is the court paper that basically lets you know that you have been sued. So courts, when they cannot issue that, your landlord can't send that to you. But right now there's an exception where the courts can only issue that where necessary to protect health and safety. If you do receive a summons and complaint, you have 5 days to respond. And if you receive any court papers or eviction notice from your landlord, we really strongly advise you to seek legal help immediately. Next slide, please. And so here is a photo of the summons, and this is what it looks like. Again, if you receive a summons in an eviction case, you have 5 days to respond. Next slide, please. Lockouts. So as Matt discussed earlier, the Los Angeles County Sheriff Department conducts these lockouts. But what we know right now is that they are not conducting the lockouts unless there are emergent circumstances. In addition, landlords themselves cannot lock out their tenants in order to try to evict them. They can't do this by simply changing the locks and chaining the door and blocking entry, or shutting off the utilities, removing doors and windows, removing tenants' personal property, and landlords can face criminal penalties and may be required to pay damages for doing so. If your landlord is threatening to lock you out, please seek legal help immediately. Next slide, please. Landlord entry. Normally, landlords must give a sufficient notice, at least 24 hours, to enter your unit. And they must specify the purpose, repairs. Are they going to, fix a busted pipe or something like that? But because of the nature of our health pandemic, in which, social distancing is encouraged, if repairs are not urgent, you should request to your landlord that they postpone this repair. And if repairs are needed to address an emergency, you can request that they wear masks and protective equipment for workers, sanitize the spaces where they're doing their repairs after they're done. Another thing you can ask is like narrowing the time frame. Sometimes when repairs are being made, they'll say like from 9 to 5, someone will come and fix it. But instead of having such a broad range, you can ask them to say, how about just 3 to 5 or something even narrower than that. Next slide, please. Requesting repairs. So it's your landlord's duty to provide you with habitable premises. It needs to be livable, it needs to be safe, and a place where you can be healthy. And it doesn't matter if you've agreed to other, agreement that it doesn't need to be habitable. They should absolutely provide you a habitable space, especially during a pandemic and we have to stay at home, right? And so when it comes to requesting repairs, you should definitely, ask for them. You still have the right to ask for them, and to ensure that your unit is in a livable condition, consistent with the building and health and safety codes in LA City. Next slide, please. And I'm going to turn this over to my colleague, Yael.
Hi, everyone. My name is Yael Pineda. I am also part of Tzedek's Preventing and Ending Homelessness project. And now we're just going to talk about the way that you can get free legal services if you live within Los Angeles County. So our project, the Preventing and Ending Homelessness project at Tzedek, is offering a eviction prevention legal clinic. It is taking place on Mondays, Wednesdays, and Fridays from 10 a.m. to 12 p.m. and then in the afternoon from 3 to 5 p.m. And so if you need legal advice or have questions about your rental housing, you can leave us a voicemail at 323-939-0506 or email housinghelp@betzedek.org. You can also visit us at www.betzedek.org.com for additional resources during the COVID-19 pandemic. We also have the same flyer in Spanish, and we will be giving a Spanish presentation on the same content in a few days through the LA Public Library. We are offering English, Spanish, Tagalog, and Russian translation for tenants here in Los Angeles County. And now I will turn it over back to Matt.
Thanks. So this is just general resources for LA County. And as we mentioned, you can find a guide to tenant protections on the resources pages at Tzedek, which is the first entry there. These resources include a sample letter for tenants, as mentioned. We also include contact information for the LA County Bar Association. You can find an attorney there specializing in landlord-tenant matters. And we also included Housing Department in LA, the Housing Department website. They have a template letter as well for notifying the landlord. And they also will help you out with finding out whether your apartment is rent controlled and answering other questions like that if you live in the city of Los Angeles. So at this point, that pretty much concludes the presentation. We're going to turn it over to questions. I think a lot of questions have come in the chat box.
I see one question about if termination from your main source of income was not due to COVID-19, and whether they would still be allowed for rent deferment, considering that many employers are not hiring. I think that actually, Yael, could you go back to the slide, the one that's concerning non-payments, the first one on non-payment of rent.
Which
Sorry,
slide?
yeah, that one, yes. So that explains like all the types of reasons that someone that a tenant will be protected because they're unable to pay rent due to financial circumstances related to COVID-19. I would recommend in this situation, think about like whether any of these things might apply, but I would definitely recommend getting legal assistance to see if there's perhaps some creative way that you might be able to fit under the law, and just really kind of assessing the facts and seeing if there's any way that this might apply to you. I will point out that the law does not protect people that can pay their rent. So that's an important distinction. But for somebody that's not quite sure if they fall under the laws because, perhaps they lost their job beforehand and they are now struggling to find new employment, I would recommend talking to a lawyer. And as we mentioned, as Yael mentioned just a few minutes ago, we do have a clinic that's available to tenants with these sorts of questions.
So another question, does the COVID-19 protections apply to mobile homes as well? I would imagine that they do. I think that dwelling units is defined fairly broadly. So yes.
Yes.
There's also a question that
Yes,
says,
I was just going to read the.
oh, go ahead, Hannah.
Oh, go ahead.
Yeah, there's another question
Oh,
that
it's
says
okay.
that they had 5 months to repay because their lease is up at that time.
Oh, I understand the question.
Where's that question?
It was at 3:20 p.m.
Okay.
Yeah,
Sort of hard to filter through this. Sorry, go ahead.
Yeah, so it sounds like this person might have been asked to sign a payment plan. I think that's what I'm gathering from this question, that it says they made me sign the agreements before the tenants knew about this information, and the landlord also made them provide documentation. So it's possible that maybe this tenant had signed a payment plan. I think in this case we would recommend talking to an attorney too. I mean, normally everyone would be permitted to have that 12-month period, and the 12-month period doesn't even start until the local emergency period ends. But if you have signed a payment plan, then perhaps your obligations might be different.
So we have another question. What if termination from your main source of income was not due to COVID-19? Would we still be allowed for rent deferment, considering many employers are not hiring? So
that was, go ahead.
I'm sorry.
I was just saying, I think that was the one. Yeah, that was the one I was saying was, I was recommending to be,
Oh, I'm sorry.
to look at the law and just, see if there is any way that they could fall under it. But did you have is there any additional information you wanted to provide?
No, I was just thinking about it. No, I'm sure you handled it correctly, though.
Okay, and I just wanted to add the definition of residential real property, which is in the LA City eviction protections. Somebody was asking about mobile homes. So the way that residential rental units are defined is any dwelling or unit that is intended or used for human habitation. So that is quite broad. I will point out that I haven't in our clinic or in my other work at Tzedek, I haven't worked with anyone that's in a mobile home. So I haven't checked that out personally, whether that definition would fall under the law. Do you have any other questions? I think that's it, unless, yeah. Okay, should we wrap up then, or?
Yeah, I think so. We would love to thank everyone for tuning in and listening, and we really hope that it was helpful. Tzedek loves to be part of this process to help tenants sort of navigate the waters during this very, very difficult time. Thank you again, and we wish everyone a great afternoon.
Yes, thank you, everyone, and thank you to the LA Public Library again. Oh, one question. Is there any question?
Yeah, there's a follow-up. How would I find out about mobile property? And I think that's one question that we can direct to our clinic as well.
I think so.
And then actually, should we just put up the clinic slide one more time? Just to close, and if anyone wants to copy down the number, if anyone wants another chance to do that. Great.
It's up on the screen.
Great. And then in case anyone is having trouble reading it on a smaller screen, the phone number is 323-939-0506. And you can also email housinghelp@betzedek.org to request an appointment. Great, thanks everyone for listening.
Thank you.
Thank you.
Thank you.